I should say, Mr. Mendez, we lost contact with you at about 1:15, and we then adjourned. So you haven't missed anything as far as I'm aware.
Thank you very much, my lord.
Yes, Mr. Boyle.
I apologise, there was an electricity surge in Trinidad.
Yes, Mr. Boyle.
My lord, I was going to deal with multiple non-delegable duties, but by way of some early housekeeping and perhaps assisting Lord Pentland with some of his inquiries about documentation, and indeed from recollection, Lord Stevens, can I just give the following references? Pages 117, 154, 155, and 159 are a series of receipts for services or service, singular, rendered. And in particular, 117 is not a receipt, it's the note from the February attendance. Patient attended under care of Dr. Gertz for surgery today. And then on page 155 and 154, we have receipts from the 3rd of February. On 154 from Gulfview Medical Centre, $1,000 for medical services by Dr. Roopchand, page 155.
So this is this is stamped as to signify it's been received, I think, by the hospital.
Well, yes, and then on 155, stamped as received from Dr. Gertz.
Right, and this, well, the 154 one is received from Mr. Tesheira, the $1,000
yes,
for something services by Dr. Roopchand.
Medical services, I believe.
Medical services, I see. Thank you. Yeah.
And then again on 155, received by Dr. Gertz for medical services.
Yeah.
And then from 159, this, my lords, is the receipt, particularised receipt for the facilities provided by Gulfview Medical Centre on the 13th of April.
Yeah, an invoice perhaps, is it? I'm not sure. Were these documents spoken to in evidence? Or introduced into evidence?
My lord, I understand they were. So, my lord, the key issue we say about 159, which is perhaps the best of the documents, was if one looks at the particulars of the invoice from Gulfview, days, visit, operating room, medication, anaesthesia, camera, laboratory, IV fluids, irrigation, blood, sundries, and so on and so forth. Those are, in my submission, facilities and services being provided, but are not surgery, nor are they the actual activities that are being performed. And I say that goes to this differentiation that was apparent on the face of the original pleading, but then disappears in the later analysis, that the services being rendered by the medical centre are services of providing premises facilities rather than services facilities, activities facilities, which are those provided by Dr. Gertz and potentially Dr. Roopchand. So,
well, just before when you look at the particulars, they include medication, a sum for medication, a sum of thousands of dollars for anaesthesia. So it's not simply, well, On its face, it looks as if the hospital is charging for the anaesthesia.
My Lord, there's a difference, of course, between the administration of the anaesthesia, which is page 158, which is Dr. Roopchand's separate receipt.
Yeah.
Was there actually any evidence about these documents?
Yeah.
What can we take from these bits of paper now?
Well, my Lord, these are the
agreed bundle.
This is the agreed bundle in circumstances where the medical documents and medical evidence was accepted by the learned judge at first instance.
This document isn't one of the more obvious ones. It's dated the day of Mr. Tesheira's death.
What's the day of his admission?
Do we know, did this piece of paper ever leave the hospital?
I think if one looks back at page 157, my lord, and I am cautious here because although this was certainly in the bundle, then I don't think there's actually any reference in the transcripts, at least the transcripts that are in the bundle, to these documents. The $300, where one can see Dr. Roop, that is Dr. Roopchand, is actually from the aborted surgery from the February. And as it says there, that the balance is going towards the next bill. So my understanding is that the receipt effectively at 158 is the receipt that is given by Dr. Roopchand for the monies that were owing from the previous surgery, not from the one during the course of which he died. But I am cautious about obviously descending into evidence.
Yes. Yes.
I couldn't quite follow that. So Dr. Roopchand, his fees were paid through the hospital, is that right or not? Or am I picking that up wrong? Or do we just not know?
I'm afraid I can't, I'm not in a position to assist your lordship with that, but what I say is that what is clear is that if one looks at 159, the hospital is rendering an invoice for its services which do not extend to the provision of surgical or anaesthesia services. And that's where I perhaps leave it. The point I was making, my lords, was that this is, when one is looking at the evidence as to what the antecedent relationship was and the extent of the duties, which I'm going to come to shortly in terms of paragraph 23, this is a physical manifestation of the situation that was in fact in place on the ground on the day in question.
Could hardly have been written after 11 o'clock when he died.
Yeah. Forgive me, Lord.
But it's dated the same date as his death.
Yes,
and he died at 11:30 p.m.
Yes. So it's the date of admission. It's so that's the bill that was being drawn up on the face of it on the day in question.
You're drawing these documents to our attention now, at this stage of the appellate procedure. Were the courts below, particularly the trial judge, asked to make any findings in fact based on this material? As to the relationships which were in play?
My Lord, the issue...
Who was responsible for what, etc.?
It didn't arise, my Lord, because there wasn't an argument differentiating between the first appellant and the second defendant and the second appellant at that stage. The issue arose because of the non-delegable duty.
Surely nothing could have been easier than for the first appellants to set out clearly in the evidence what the contractual and other relationships were between these various parties. Now you're asking us to draw, I think, a number of inferences and conclusions on the basis of this rather opaque material. It all seems quite strange.
The difficulty, my Lord, is this. The burden is on the claimant in the first instance to prove the duty in the relationship.
Well, I'm not sure that's right. In Woodland, Lord Denning is quoted in Cassidy as saying that the ordinary rule is there's a non-delegable duty owed by the hospital. There's an exception where the defendant was employed by the patient, but it's for the defendant to establish that. You find it if we go back to Woodland.
Not here, will I put them under this page 67?
In order to get it quite quickly. Yes, I think it's after he's quoted Cassidy in paragraph 15. Yes, here we are. Yes, we're, in paragraph 15, the page number begins with 295, but I can't.
2952, my lord, is paragraph 15.
Yes,
and
well,
the Cassidy section.
The second passage quoted from Lord Denning in Cassidy is saying that the defendant he cannot escape the consequences of a breach of his own duty, but he can escape responsibility for collateral or casual acts of negligence if he can show that the negligent person was employed not under a contract of service but only under a contract for services. So that's talking about the employer of.
My lord, I read that as saying that where a principal owes a direct duty of care, it can, in certain circumstances, show that actually the person who is then negligent is in effect an independent contractor that has been brought in to perform those services.
Yeah.
But what we say here is that we identified as early as the letter of response at page 67 that was not the situation in play at Gulfview in 2004. Yeah. We said as soon as we possibly could,
well, that's a lawyer's letter, isn't it?
Well, but
anyway, we understand what your position is. We're rather taking a lot of time over something where it's perfectly clear what your argument is.
Thank you. So what I would say then, my Lord Pentland asked, I believe it was my Lord Pentland who asked for the references in Dr. Pitts-Miller's evidence, and it's 803 line 40, 804 lines 1 to 2, and 808, 17 to 19, and 24 to 26. My Lord Stevens asked why did we not controvert the evidence that was put by the claimant in terms of the experts called. My Lord, the two experts were in the field of haematology and anaesthesia rather than in respect of nursing care, and the allegations against the first defendant were in respect to the provision of nursing services and the administration rather than anaesthetists and haematology. And my Lord,
I agree with you. There was no nursing expert called, and the issue doesn't arise actually on this appeal because you won that point in the Court of Appeal. But I certainly had reservations about the fact that it's only a nursing expert that can talk about the expertise of nurses. Certainly surgeons and anaesthetists, I would have thought, would have had sufficient expertise to talk about what nurses should or shouldn't be doing. But be that as it may, it's water under the bridge.
But of course, there is no surgeon here. And it may be that that's because of the situation that arose at the time of, well, the medical evidence, of course, postdates the pleadings, but it predates the release of Dr. Gertz, as I recall it. I'd want to check that. But what we say, my Lord, the specific question was, well, why did you not call evidence to controvert? And the answer is because we didn't see that it was evidence that could relate to us. And that was ultimately the finding that
I understand.
we get to. My Lord, can I just, before descending to the pleading points, also the references on page 1107 to 1113, these, my Lords, are the assessment by the judge at first instance of the issues, and what we say is that those 6 pages set out the issues that were live between the parties as far as the parties were concerned at the commencement of the litigation before the learned judge. And I'm not going to take the time to read them out. Hopefully by providing those references they can be taken on board, but they do not include issues of vicarious liability or non-delegable duty as I read them. And if I'm wrong, Lord, then please accept my apologies in advance, but I don't see in that list of issues the questions arising that then trouble the Court of Appeal when they make their determination.
Well, I think the passage in Woodland is at paragraph 15, the Denning quote, which comes from page 362 to 363, and that is whether doctor or surgeon, be he a consultant or not, is employed and paid not by the patient but by the hospital authorities. I'm of opinion that the hospital authorities are liable for his negligence. And that to me at present would suggest that the burden is on the hospital to establish that the consultant was employed and paid by the patient.
Well, with respect, I would disagree in the sense that we've identified at the earliest possible stage that the money was being paid by Mr. Tesheira to Dr. Gertz. We do have those receipts that I've brought to the board's attention this afternoon in any event, but those were issues that were within the knowledge of the claimant, having regard to the bank statements and financial records of Mr. Tesheira. And in those circumstances, well, given that the payment is being made directly by Mr. Tesheira to Dr. Gertz, is not necessarily a matter that can be directly evidenced by the medical centre. They would simply be able to evidence a negative, that there was no payment made to them in respect of Dr. Gertz's services. There are, however, the receipts from Dr. Gertz saying that he received monies from Mr. Tesheira, and we would say that in the circumstances that was sufficient. However, whatever weight one wants to put on that evidence, there is certainly evidence to be placed on the scale and nothing to counter it. And having raised the issue in the first instance and raised the issue with those documents, there is nothing which in my submission would permit the Court of Appeal to do what they actually do, which is to say we both disregard the documentation and the suggestions that are in evidence, and we then thereafter presume that there is a non-delegable duty in place. And I say that either you have a presumption of non-delegable duty contrary to the exceptional suggestions of Lord Sumption, which is then nevertheless displaced by the documentation we have, or one starts de novo and says it's been identified at the first possible stage that there is an issue here, let's go and prove it. And both sides have the availability of documentation in that respect.
Mr. Bolton. Am I understanding that paragraph 76 in the judge's opinion, judgment,
Forgive me a second.
sets, which you've just drawn to our attention,
yes.
Electronic bundle, page 1107, deals with the contested issues at the trial, not the admitted issues.
But there wasn't an assertion of vicarious liability in the first instance. So would it would it assist me, Lord, if I...
But am I right that that paragraph is simply explaining what the disputed questions were at the trial, not what was admitted?
But there was neither pleading nor admission.
Well, that's, so far as vicarious liability, you say that, but we've also got the contents of paragraph 23.
Should I turn to those now, my Lord, and address...
A matter for you entirely. Speaking for myself, and very provisionally, I just don't see that paragraph 76 really helps.
Mr. Bolton, I don't know if I'm being heard in court. Could I just ask you a related question to that? Because, as I understand it, the list of issues in quoted in paragraph 77 is that, I think, which we find at page 767 in the bundle. Is that right?
Yes, I think it is.
767.
767.
So that was...
Yeah, I think it is. It was dealt with from day one of the trial, which we don't actually have a transcript for.
That's what seems to be quoted from. And I draw attention to it because that was a list of issues drawn up at a time when Dr. Gertz was still one of the defendants. So as I read that list of issues, where it says, did the defendants or either of them conduct coagulation screening tests and so on, it's referring to what Dr. Gertz and the second appellant were doing. There seems to be no separate issue raised in relation to the first defendant, that is the hospital. And so it seemed to me, but please help me, that this document, the list of issues, presupposed that there was a non-delegable duty, and that in light of that, what had to be looked at was whether Dr. Gertz or the second appellant had behaved negligently. Please correct me if I'm wrong.
My Lord, one has to look at that, in my submission, in the context of the pleading that I was about to address in terms of the original statement of case. But, my Lord, my appreciation of it is that there wasn't at that stage any argument about non-delegable duty that would effectively fix the first appellant with duties in respect of breaches by the other two defendants in those respects. And what was actually being looked at here was, it's an unusual wording, because if there were three defendants at the point when it was drawn, one would expect or any of them rather than either of them, or more specificity.
Well, that's the point of my question. That this list of issues doesn't seem to single out the hospital as an entity with duties separate from those which are owed by and fulfilled by Dr. Gertz and the second appellant.
Well, these were specific tests, my Lord, that were being identified that would be within the purview of the individual defendants.
Yes, I see. Thank you.
He's trying to read into that we're not mentioned because we must be covered globally. That's just not
I say we're not covered. This is not a global pleading or global list of issues that identifies us as being sat at the same table as the second defendant or the third defendant when it comes to the individual duties. And I say that in the context, my Lord, of the original pleadings and the original particulars of statement of claim, and the way in which it's put. And, my Lord, if I go back to page 6, what we say is paragraphs 3, 4, and 5 identify the three defendants in very different terms, and what is clear is on the amendment, if one looks at paragraph 3, one can see that what was then grouped, the medical centre was used as a phrase to describe the first defendant, notwithstanding the fact that later in the day it became apparent that medical centre was being used as a shorthand for everybody, all three of the defendants, and everything pertaining to the treatment. Paragraph 4, a specialist urologist provides the person's medical treatment for reward at the medical centre. 5, third defendant from time to time or having had the use of the premises or facilities. If we then look at the duties which are set out at 6, they pertain to the first defendant only, and the duty on the first defendant insofar as it pertains to the second and third defendants is set out at 6A on electronic bundle page 6. That is to say that the second and third defendants, who are described there as visiting consultants and specialists, with the emphasis on visiting, and that is the pleaded case, not employed or somehow vicariously liable. Visiting consultants were sufficient in number, properly qualified and reasonably competent. In other words, we shouldn't allow people who do not know what they're doing into the premises, but that is not the same as preventing them from acting as they do within the course of their provision of services. Then to provide adequate equipment, and then to maintain and have access to the reference medical records of persons admitted. So those are the duties identified at paragraph 6 as against us. And paragraph 7 identifies duties against the second and third defendant, which is specific to the administration of treatment. And if it were to be suggested that there was either a vicarious liability or a non-delegable duty that covered the acts and omissions of the second and third defendants, then in my submission, paragraph 7 would be followed by a 7A that says, for the avoidance of doubt, in circumstances where the hospital had the overwhelming primary duty of care, they were liable in respect to the acts and omissions of the second and third defendant, and were unable to delegate their responsibilities to them. But that is not then said. And then, my lords, if we then go to paragraph 10, which says that the deceased was admitted to the medical centre for a surgical procedure. The admission is at paragraph 10, vis-a-vis the first defendant. And then at paragraph 11, and this is, in my submission, a key way in which the claimant put the case. The TERT procedure was performed by the second defendant as surgeon, the third defendant as anaesthetist, and the servants and or agents of the first defendant as attending medical staff. There is a clear differentiation in my submission between the three defendants at paragraph 11, which I say is not then remedied by the back door by some later pleading. And we can see that at paragraph 12, the first defendant acts at the request.
I do apologise, Mr. Boyle, but if you take that line and just turn over to electronic page 10, and you have the particulars of negligence of the first defendant, its servants and agents. The very first one is in relation to PT and PTT tests, which are carried out by, not by the nurses, they're carried out by the doctors. So the allegation, presumably, is that the doctors were the agents, servants of the hospital.
Well, there's a presumption there that I do not say survives the fact that there are allegations specifically against the second defendant and third defendant in respect of their individual conduct, and the duty is to do that which is required of them by the treating physicians. So the allegation can be that you did not fail to ensure that PTT tests were conducted on deceased immediately prior to the performance of the TERT procedure. But equally, the starting point is that the only obligation and the only circumstances in which the hospital will undergo those tests is when they are required by the surgeon and or the anaesthetist. And we say that if one looks at paragraph 11 and paragraph 12, it is the allegation is that you do it at the request of or pursuant to the directions of the third defendant. It is not suggested that the duty is to do those irrespective, nor is it suggested that there is some sort of vicarious liability on the part of the hospital for those who are performing surgeries within.
What do you say about subparagraph M at the foot of page 7, transfusing group O positive whole blood into the deceased, and or permitting and or instructing same to be transfused into the deceased?
We say, my Lord, that those are acts that are carried out at the behest of the individuals who are responsible for the care of Mr. Tesheira once he goes back into the operating theatre.
As I understand this form of pleading, that's an allegation of negligence for which the hospital is said to be liable.
But there's a difference, my Lord, in my submission between the pleading of a duty and the pleading of a breach. If the duty is, because the breach, one can plead in standard form as is done here.
Well, it's headed particulars of negligence.
Yes, my Lord, yes, but that's, the pleading is there in respect of the first defendant, its servants or agents, where that is specifically by its the previous pleading at paragraph 11 excluded the second and third defendants because they're identified as separate individuals, and the attending medical staff are the servants or agents of the first defendant that's identified.
I see.
There's a difference, of course, between if there were a failing by an employed nurse or a nurse in the employ of the medical sector, then there would be vicarious liability potentially in that regard. But what we say, my lords, is that if one then looks at the way in which paragraphs 22, 23, 24 are pleaded, and particularly if one looks at the way in which paragraph 24 is pleaded, before we come back to paragraph 23. Paragraph 24 identifies the first defendant, its servants or agents, and or the second defendant, and or the third defendant, and then gives these various particulars. But it does not say, and it would be, in my submission, a relatively straightforward, basic level pleading. You could either add to paragraph 24 whether individually and or as servants or agents of the first defendant or for whom the first defendant was otherwise liable. And that would be a straightforward pleading point that one would expect to be taken if that were the case to be advanced.
Now, if I can intervene, you're now 10 minutes over your allotted time.
Forgive me, Lord.
Well, I'm not attributing blame, but the only point is you're going to have to wind up so that we can hear Ms. Deal and Mr. Mendes. Yes, I think Lord Hammond may have a question. Hamblin may have a question.
He's on mute.
Sound.
Have we lost?
He's on mute, I think.
Have we lost sound? Hmm?
He's on mute.
Yes, Mr. Mendes. Can any of you hear us? I don't think they can hear us. No. Okay, lost sound. Well,
saved again by the bell, I suspect.
Yes. Well.
All I was going to do is deal with paragraph 23 very briefly, but
we'll let you finish your submissions, but it'll have to be very brief.
Yes.
When we resume. But we'll adjourn, I'm afraid, for another few minutes to let this sound problem get sorted out by the engineers. Well, I gather, Mr. Mendes and Lord Sales and Lord Hamlin, that you lost sound for a time. We were being taken by Mr. Boyle through, especially the particulars of negligence of a first defendant set out at pages 10 and 11 of the electronic bundle. I think we've completed that exercise, and I just invited Mr. Boyle to bring his submissions to a close, as he's somewhat over time.
My Lord, taking it as very, very swiftly, because I don't want to repeat the matters which were already reduced to writing.
Yeah.
What we say is, if one looks at paragraph 23, it is quite clear that each of the three defendants, particularly in the circumstances outlined in paragraph 11, have separate functions. And it is not, for instance, to be suggested that the monitoring of bleeding and the managing of bleeding would be performed by the same individual, and therefore these are a shotgun approach to the allegations, and it is not and cannot be that the duties then manifest in each of the three defendants. And what we say is, and it brings us back to the Woodland point, if one looks at how the particulars are pleaded, they're pleaded against each of the defendants individually, and if the Woodland point, the non-delegable duty, arises from the admission in paragraph 23, how can it only then vest in the first defendant, the first appellant? Because the same duty is being pleaded as against all three of the defendants. And therefore, in my submission, this idea that the Court of Appeal fall into error when they say, well, you have an organisation here, which is the umbrella organisation, Gulfview Medical Centre. What Para 23 must do in respect of the medical centre is create a non-delegable duty. But it doesn't then create the same non-delegable duties in respect of the second defendant or third defendant is inherently illogical where the pleading is made as against all three defendants in identical terms. And in my submission, it would be wrong to simply fall into the trap of saying the hospital, being an organisation, can be the subject of non-delegable duties, but the individuals, particularly Dr. Gertz, who is the gateway, cannot. If somebody from the hospital provided Dr. Gertz with the wrong equipment, he would not then be able to escape by saying, I didn't employ somebody from the hospital, because he would have that non-delegable duty in respect of the surgery that he was performing. And we say that that is why paragraph 23 cannot give rise to this non-delegable duty which the Court of Appeal give it. And we say that is at the heart of the non-delegable duty point in this appeal. My Lords, I'm very grateful for the additional time you've given me. I hope that I've used it as swiftly as possible.
No, thank you very much, Mr. Boyle. I mean, I appreciate we've had to have some adjournments, and that's why you've lost some time, and I think at the end of the day, you've ended up with about the right amount of time.
If I've spoken too quickly at any stage, I apologise.
No, not at all. We appreciate people who go through things quickly. The Steele.
With that heavy hint, my Lord. My Lords, this was, we say, obviously a tragic case, but it was essentially an ordinary clinical negligence action, which has ended up before your Lordships. And that is because the claimant, the respondent now, reads into a very ordinary statement of claim. A claim, and moreover an admission, that an anaesthetist owed an absolute duty, merely as part of the surgical team, to prevent Mr. Tesheira's death. Effectively a duty of result, where breach was essentially made out because that result was not achieved. And of course, the courts below acceded to this. And the respondent needs to do that because the case, as evidenced at a half-time stage against Dr. Roopchand was, we say, so weak that the almost inconceivable happened and a half-time submission of no case to answer was made. And of course, trial judge acceded to that and the Court of Appeal upheld it on different grounds. But if the respondent's case is correct, then her claim was brought on a basis that would fly absolutely in the face of very long-established law of clinical negligence, and yet the courts below just nodded it through. And that would be striking, and it would be so striking that that would be an indicator, we say, that either that's not the proper construction of what happened below, or that something went wrong. Now, of course, this was a case that was striking in many ways, because by the time it came to trial, it did not involve the main protagonist, Dr. Gertz. There was no relevant lay evidence. It was entirely a case of experts. You've heard this morning, my lords, that neither expert had ever been in court, neither had even the faintest familiarity with the test that the court was going to have to apply in a clinical negligence case. So neither could address or did address the test that had to be addressed. The Court of Appeal then overruled the trial judge on almost every point and made their own findings a fact of negligence of causation. And we say that the court simply misunderstood the law, and they placed on the experts more weight than at the end of cross-examination their evidence could possibly have warranted. My Lord raised to the point this morning, my Lord Stevens, about there being concurrent findings of fact. And of course there are some. But they were findings, we say, that were based on erroneous propositions of law. So if the erroneous propositions of law go, then so too do the findings. I've set out at paragraph 22 of our case, obviously I need to remind your lordships of the test from Conticore or Davy and Roy. Relevant passage in Davy and Roy is at 2488, where what was being accepted there was essentially to come from a previous case, that the facts or facts found must be such as are necessary for the foundation of the proposition in law to be subsequently applied to them. When that goes, then this is, we say, one of those very rare cases where the concurrent findings go too, and your lordships are not bound by them. I will, with your leave, address the points in this order. Firstly, the scope of the duty of care on Dr. Roopchand. Secondly, the breach of that duty. And thirdly, causation. And the scope of the duty of care, we say, is where really all of this went wrong, where it started going wrong, because both of the lower courts took an approach to the pleadings which ignored the law and set the scope of the duty on the anaesthetist really unfeasibly wide. This is the, now we should refer to it in shorthand, paragraph 23. My lords, we say that is at an extraordinarily high level of generality. It's applying to all the defendants, notwithstanding the very, very different positions that they all filled in the run-up to the 13th of April and, of course, on the day. No attempt is made in paragraph 23 to differentiate between them. We make no criticism of that. This is a very general pleading. But notwithstanding the admission, particularly because of the admission, the courts below had to identify, we say, the scope of the duty of care on each of the defendants at an individual level. They self-evidently had different responsibilities. They might have had the same overarching duty to take reasonable care. But reasonable care to what? One has to, in a case, a clinical negligence case in particular, identify who should do what and who does what. That has been part of the law since Wiltshire, which is obviously in the bundle of authorities, that there is no team responsibility. the effect of what the respondent is saying her pleaded case was that was then accepted by the lower courts is that because of this pleading at paragraph 23, at this very high level of generality, there was team responsibility on Dr. Roopchand, who of course by this point stood alone as the member of the surgical team because Dr. Goetz had vanished, for everything that happened in the run-up to the surgery, during the surgery and after the surgery. And it goes further because the scope of the duty of care encompasses, in accordance with Khan and the references at 2697, the purpose of the duty. It was erroneously, we say, accepted by both of the lower courts that to all intents, paragraph 23 sets out and is then accepted by the defendants a duty of care being one of result, prevention of fluid overload, protection from excess bleeding. Now, of course, there are various systems of law which do include obligations of result, but our law of negligence is not one of them. And least appropriate of all, say, in a case of clinical negligence, it is reasonableness of action that the court had to be considering below, not warranty of outcome. If this very general paragraph 23 were genuinely to be regarded as an assertion of a case that an anaesthetist, simply by dint of being a part of a surgical team, is responsible for the outcome of that surgery, that would be groundbreaking. And nobody even touched on that. And that, we say, is because that was never the way that that could properly have been construed or should properly have been construed. This was setting out the overarching scope of the duty, but you then had to, the lower courts had to, descend into the specifics of the roles of the posts of those who were actually undertaking the various responsibilities on the day. What was the purpose of Dr. Roopchand's duty?
Why didn't Dr. Roopchand simply plead that he had got no obligation to ensure the outcome?
Well, that was how it ended up being interpreted, my lord. For an example, is 1483, which is from the Court of Appeal. One looks at paragraph 232, my lord. Now, this is obviously just one example, and I've set out a number of other factors in there, or there are other details in the case. Second, appellant did not take any steps to prevent the deceased succumbing to excessive bleeding during the 20 minutes under review. Second allegation is much wider and involves the consideration of the second appellant's actions not embarked upon by the judge. The evidence, however, is that after the discovery the deceased was bleeding heavily, the first step taken, I think, to prevent the deceased from succumbing to excessive bleeding in accordance with the standard of care identified by the experts was the transfusion of 2 units of blood. It is clear that this step was not sufficient to arrest or control the deceased bleeding, since he'd already succumbed to excessive bleeding by the time that they first did that. So they're looking at the fact that he had already succumbed to excessive bleeding as an indicator that he cannot have taken sufficient steps to control the bleeding. So,
I'm sorry, my question was aimed at a slightly different area, and that is, paragraph 23 makes an allegation that there is a duty on your client to ensure. And I was just simply asking, why not put in the defence that there was no duty on the anaesthetist to ensure anything?
well, the way my learned friend put it is that when one looks at paragraph 23, it actually contains all that one would expect to moderate that. It has careful, minimise properly. If you're construing paragraph 23 properly, then it shouldn't be, we are asserting a duty of ensuring an outcome, warranting an outcome. And that, we say, is effectively what the admission was put into, an admission of how paragraph 23 should properly be construed, which is, yes, of course, there's a duty of care on all of the three who've been sued at this stage. And of course, that duty may well overlap. But the specifics of the scope of that duty don't, and that's what needed to be analysed. So when the admission is put in, and I note that my learned friend this morning said the admission should never be made. Barrister, of course, will always tend to assume that we could have done things better. But in fact, the admission that was put in, if one is analysing para 23, as we say it ought to be analysed, the admission is really uncontentious. In an ideal world, perhaps one goes through and sets out the fullness of the argument that is now being made. But in fact, paragraph 23 is relatively uncontentious and the admission is uncontentious. What then ought to have happened, we say, is the very much more careful and more detailed analysis of what the scope of the duty was on all of the players. And of course, we're only concerned for these purposes with Dr. Roopchand. Now, noted my learned friend Mr. Boyle's submissions on non-delegable duty, or certainly the non-delegable duty on the hospital. Not my fight. I have nothing to say on that, save for 2 points. I think when running through the receipts, and probably because it's in a completely different place in the bundle, there is at page 233 a rather fuller breakdown of the bill that was presented to, at least, whether to Mr. Tesheira before the surgery or whether to the estate after the surgery obviously isn't clear, but putting rather more flesh on the bones of the individual sums. And the second point is really this, that it would, we say with respect, be no less than outrageous if a hospital, which elected, of course, to put forward no evidence on the relationships and the arrangements, could escape responsibility and leave Dr. Roopchand, who was very much the lowest man on the poll, effectively as the last man standing. But other than that, we say nothing about the non-delegable duty on the hospital. But what now seems to be said by the respondent, at least in the case, is that Dr. Roopchand owed a non-delegable duty. Now, that is entirely new. My lords have already been referred to the relevant passages of Woodland and the distinction between the non-delegable duty and the ordinary fault-based law of negligence. There is really nothing whatsoever in my submission about the relationship between Dr. Roopchand and Mr. Tesheira that could possibly fit into a non-delegable duty of care. And certainly not one that would be sufficient to fix Dr. Roopchand effectively with responsibility for Dr. Gertz, the nurses, the hospital, even the blood bank who sent the blood when it was ordered. And in any event, the non-delegability of the duty supposes that there is a duty. And that's when you have to come back to what the scope of the duty was on Dr. Roopchand as the anaesthetist. The reality, we say, is that this was fought and is a straightforward clinical negligence claim. The court had to consider the scope of the duty on Dr. Roopchand, and in the post that he was holding on the 13th of April, and just didn't do so. The case covers a number of parts of the evidence of the acceptance of the different roles that were being played on the day. The Court of Appeal touched on this, references at 1480, paragraph 224. identifying that there is a need to be differentiating between the responsibilities that some of the protagonists were taking on and some of them weren't. But there are two specific elements that I would like to deal with. And the first is the PT and PTT tests pre-operation, and the second is the transfusion of the O+ blood. My lords, we know, and of course it was an evidence, that the PT and the PTT tests are effectively tests going to coagulation. And it is undoubtedly the case that coagulation is and was relevant to the excessive bleeding that Mr. Tesheira succumbed to. But the evidence as it came out at trial, and really as one would expect, was that an anaesthetist and a surgeon have very different interests in the coagulation properties of the patient's blood. And the relevant passage in the evidence is set out at page 853. The anaesthetist's interest in coagulation is going towards spinal hematoma, an established, recognised potential complication of anaesthetics. The surgeon's interest in coagulation is going to, can we get the bleeding to stop? They had different purposes to be interested in coagulation, the coagulatory properties of Mr. Tesheira's blood. They had a different scope of a duty of care. But because the coagulation of Mr. Tesheira's blood had a bearing on the excessive bleeding, the Court of Appeal essentially squeezed the undoubted absence of pre-operation PT and PTT tests into the wording of paragraph 23, even though there was, we say, absolutely no connection between the role, the purpose, the scope of why Dr. Roopchand might have been interested in coagulation and what these tests might have showed of relevance to why Mr. Tesheira died. What would Dr. Roopchand have been looking at if these PT and PTT tests had been carried out? And it would not have had any bearing on the excessive bleeding that Mr. Tesheira ended up succumbing to. And that, we say, is because paragraph 23 doesn't throw open the gates and say that the anaesthetist and the surgeon have exactly the same interests. They have the same scope. They're looking at this for the same reason. They don't. And they have a different scope of a duty of care, and that's something that neither of the lower courts, we say, looked at. The second point is the transfusion of the O+ blood. And at this stage, what I mean by that is the decision to transfuse the O+ blood, not the mere setting it up and putting in the cannula and letting it drip through. Now, there are issues about the transfusion of the O+ that go to the standard of care and go to causation, and I will come on to those later. At this point, I'm just dealing with the question of the scope of the duty. And again, in my submission, it shows the difficulty with taking paragraph 23 at anything other than this very, very high level of generality. Dr. Roopchand is an anaesthetist. We know from Wiltshire that you have to look at the post that the medical professional whose negligence or otherwise is being considered. We have to look at that post. The O+ blood, the transfusion of the O+ blood as a problem, didn't even feature in Dr. Pittmiller's original report. Her report is at 506 to 519. She mentions the transfusion of O+ blood at 513 with absolutely no adverse comment at all. It's not even identified as being something that, oh, well, one might have questions about this, why would this have been done? first time that it comes around is when her witness statement has effectively been drafted by counsel.
Well, she describes the transfusion of whole positive blood as a serious error.
I'm sorry, I wasn't looking at you, my lord.
Sorry, forgive me. I'm just going to note that in her witness statement, however it was prepared and with whatever assistance, those are all questions of weight which are now gone as far as I can see. She describes it as a serious error.
Oh, in the witness statement, by the time she comes to the witness statement, yeah. Absolutely. That's why I highlight the difference between the original report, which is the one that's...
What does that matter now?
Yes, I mean, this is a Privy Council, for goodness sake. We're not trial judges retrying the case on the facts.
Oh, absolutely. But this...
Or confine yourself to points that are of some relevance at this level in the judicial hierarchy.
It goes to the scope of the duty that neither of the lower courts addressed because they took the erroneous view in my submission that paragraph 23 meant that they didn't have to do that.
Your case falls down in paragraph 23 does mean that.
I'm sorry?
Your case falls down if paragraph 23 does mean that.
If paragraph 23 falls to be interpreted in the way that the trial judge and the Court of Appeal interpreted it, then yes. Yeah. But that would be so surprising, we say, because it would be absolutely contrary to such a well-established law of clinical negligence.
Well, there's been no explanation, apart from an acceptance on behalf of the first appellant, that it shouldn't have been admitted. And people define what the issues are in the pleadings.
But we're not seeking to
There's nothing necessarily wrong or unusual about a claimant choosing to plead her case at a high level of generality and see what the reaction is to that. And here, as has been pointed out on a number of occasions, the reaction was, we agree.
Oh, at a high level of generality. It doesn't get...
Is that not really finito la musica?
It doesn't get away from the need to actually analyse what the scope of the duty was on the anaesthetist in the dock, as it were. Because if you're saying, at the end of the day, that the duty on the anaesthetist, the scope of the duty on the anaesthetist, just by looking at paragraph 23, is identical to the scope of the duty on the hospital and the scope of the duty on the surgeon, that would be absolutely astonishing. It would be astonishing because it's not what the law says.
There may be very, very practical reasons for that being admitted. We know nothing about them, but they have been admitted on one interpretation of paragraph 23. There can be very good practical reasons why an anaesthetist and a hospital do not fall out with each other.
Yes, exactly.
The approach that was taken to paragraph 23, and obviously I defer to my own friend who was there, by the time of the judgment, and in particular, of course, by the time of the judgment of the Court of Appeal, was very, very different to the approach that was taken to paragraph 23 in the run-up to and during the trial. The trial proceeded, as far as one can tell from the obviously limited transcript that we have, on absolutely ordinary clinical negligence grounds. Everybody was looking at this, at least by the time the experts had left, on the basis of this being a Balaam case, on the basis that one needed to have the evidence of the standard of care, on the basis that actually there are differences in the roles that the surgeon plays and the role that the anaesthetist plays. And I give you, and that's why, of course, there was cross-examination about the need for a surgeon and an anaesthetist, or the different needs that both of them would have in approaching PT and PTT tests. So the case was proceeding on the basis that one has to have some form of analysis of the scope of the duty on the different practitioners. And all of that effectively got swept away in the judgment, and swept away to the extent of, despite the trial judge and indeed the Court of Appeal saying, well, here are the principles in Balaam, here are the principles in Wiltshire, not even identifying, yeah, but none of that really matters because actually we don't have to look at what the scope of the duty is on an anaesthetist because it's identical to the one on a surgeon. That cannot be right. And so it's for that reason, my lords, I'm saying, well, that actually, if one looks at the way that the evidence was coming out, then it was going to there being a need to look at the scope of the duty. One needed to look at the scope of the duty on the anaesthetist in respect of the pre-operation PTT and PTT tests. One needed to look at the scope of the duty on the anaesthetist as regards the decision to transfuse the O+ blood. Now, Dr. Jones, I'm not sure how to pronounce his name, Lecointe, who, nothing from Dr. Pitt Miller on this, but Dr. Jones Lecointe was very clear, and the references are 876, 877, and 878, to the decision being one for the surgeon in conjunction with a haematologist. And we know that a haematologist did in fact advise Dr. Goetz, once the PT and the PTT tests had come back after Dr. Goetz had spoken to Mr. Tesheira's brother in America, which of course we can tell 1093 was before the O+ was transfused. So when looking at the scope of the duty on an anaesthetist with the decision to transfuse the O+ blood, then the evidence that there remained at half-time was that the decision to transfuse the O+ blood was not for the anaesthetist. It was for the surgeon in conjunction with the haematologist, as in fact had happened. Now, the transfusion of the O+ may well be of relevance factually to the excessive bleeding and to the prevention of fluid overload, but it only works to fit Dr. Roopchand with responsibility for the decision-making if one ignores the actual role of an anaesthetist in the prevention of excessive bleeding. And I say again, this would be groundbreaking stuff. And there's not even a comment. And the reason that there's not even a comment to my submission is because this was not the basis on which any of the courts, any of the trial was proceeding and any of the courts were proceeding. And that, in my submission, suggests that the approach that was taken after the event was wrong. Paragraph 23, we say, is a very general assertion of a duty of care against three totally different entities in a very ordinary clinical negligence case. But the effect of the lower court's conclusions is to hold the anaesthetist responsible for things which the evidence showed was simply not part of an anaesthesia role. It was because he was simply part of a team where there was an unhappy outcome.
The difficulty about having to pick through the evidence at this level, is the proposition which you've just advanced is, to my mind, a somewhat unusual one. That is, the anaesthetist is at the head of the patient, controlling what bodily fluids go in, what transfusions are made. And just to say, because the surgeon and a haematologist came to one view, absolves the anaesthetist of all responsibility. It is one which one would have to go through this evidence with enormous detail in order to find that it was true.
Well, when you have got Dr. Jones Lecointe saying it's for the surgeon to decide in conjunction with the haematologist, and we know that Dr. Goetz did discuss with the haematologist, not with Dr. Roopchand. Dr. Roopchand's not even mentioned in the clinical notes as being someone that Dr. Goetz is talking to. Completely different, if the needle went into the muscle rather than into and so the transfusion that was being carried out, irrespective of whether it was O+, or anything else, was being done incompetently. But this is a question about the decision-making. Who decided that O+ was the appropriate fluid to transfuse into Mr. Tesheira at that point in time? And in my submission, there was nothing, by the time one reached the end of the evidence, that showed that that fell within the scope of the duty on the anaesthetist. He had to organise the fluids, he had to put them in, he had to make sure that the patient was staying stable. But the actual decision-making, no, that's for the surgeon speaking with the haematologist, and that was what the evidence says.
What relevance can the evidence have? Sorry, what relevance can the evidence have when it comes to interpreting the pleadings? You can't use the evidence as an aid to construction of the pleadings.
No,
pleadings are the pleadings.
But it is a fairly good indicator, we would say, that the pleading, the proper construction of the pleadings did not rule out, and indeed, because of the way that it was put against all three defendants in identical terms, made it essential for the trial judge to actually do that breakdown. What is the scope of the duty on these three entities who are all being accused of owing a responsibility?
That conceivably might amount to a misdirection by the trial judge to approach the meaning of the pleadings by reference to the evidence. It's, I think it's put this way by Mr. Mendes, it's the tail wagging the dog.
It would not be a misdirection if one starts from the pleadings and what do they actually mean? If you're
in the absence of the evidence doesn't matter.
In the absence of the evidence.
And why do you need to go any further?
With the pleadings.
Why go any further?
And you've got three entities who, as a matter of common sense, before one gets into any of the evidence, will hold very different responsibilities. One of them's the hospital. Is obviously not going to have precisely the same obligations as the anaesthetist or the person wielding the scalpel. What you've got to do, rather than assuming that they all owe exactly the same duties, basically all overlapping each other, you're responsible for him, he's responsible for you, you actually have to break down that duty of care that's asserted in paragraph 23 and say, well, what does it mean? What is the scope of that duty on each of the people against whom it's being alleged? And in my submission, it's simply, it's such a very general assertion of a duty of care that it's not good enough just to say, well, that must be, you admitted it. Well, yes, I did admit it. I'm an anaesthetist. I do owe these duties. But the scope of those duties is very different from the equally admitted duty on the surgeon. When it comes to a duty to prevent excessive bleeding, the surgeon is the one holding the scalpel. The surgeon is the one that's in there trying to pack the wound and stop bleeding. The anaesthetist, however one construes paragraph 23, the anaesthetist can't be regarded, even before you get into the evidence, as having exactly the same responsibility for getting in there and stopping the bleeding.
Do you accept Lord Pentland's proposition that you can't use the evidence to construe the pleadings?
You can't use the evidence to construe the pleadings, but you can use the evidence as it comes out as a pretty good indicator of the way that everybody was approaching the pleading, which was not that everybody has an identical duty and that there's no relevance of the distinction between the obligations on the hospital and the obligations on the anaesthetist and the obligations on the surgeon. And the way that the evidence was coming out, on the claimant's case, of course, 'cause it stops at half-time, was, in my submission, a very, very clear indication that this was not a case where anybody was proceeding on the basis that they all owed exactly the same responsibilities. They might have, all of them, had responsibility to take reasonable steps to prevent the bleeding. I'm not taking that directly from paragraph 23 in the concept. But the duties that the three of them had to, the responsibilities that the three of them had to exercise in order to fit in with this overarching framework of all of them having a duty to take reasonable steps to prevent the bleeding, were, in my submission, very, very different, just as they are in any clinical negligence case, because the hospital is not expected, absent questions of non-delegable duties and vicarious liability, the hospital is not expected to be wielding the scalpel and plugging the wound. The anaesthetist is not expected to be wielding a scalpel and plugging the wound, and the surgeon is not expecting to run to the blood bank and source the blood from there. They have the same duty, but they have different responsibilities as part of that duty. And that was something in my submission that, irrespective, and all the more important because of the admission that was made in the defence, the trial judge and then the Court of Appeal had to grapple with. If I can turn to the question of the breach of duty, the main problem here, we say, is the standard of care. You've already heard from my learned friends this morning about the difficulties, we say, with the approach that was taken to Appellant and Blytho. It's not a res ipsa case. The claimant had to prove negligence. Don't start, notwithstanding the approach that the trial judge took, with the fact that Mr. Tesheira died, and work back from that to the fact that something must have gone wrong and an explanation was called for. An explanation might be called for by the family because they're human and a loved one died, but that's very different from it being a question of law that an explanation is called for. There's no dispute at trial, or indeed on appeal, that clinical negligence case necessitates an approach in line with Blytho and Blytho, and Dr. Roopchand is not liable in negligence, we say, unless his acts or omissions, to the extent that they fell within his scope of duty, were those which no reasonable anaesthetist would have made. And we say that it is axiomatic that there has to be evidence adduced by a claimant who has the burden of proof, not of what one other doctor would do, but what no other reasonable doctor would do. There are three, let me say, and I only raise these as examples, my lord. I appreciate you're not a trial court. The O+ transfusion, the transfusion of the later products, and the timing of the transfusion, effectively the delays. The evidence that one gets from the experts by the time the claimant closed her case was, to use the words that came up in Griffiths and Toohey that were referred to in Gulfview's case and Cindy, essentially a bare ipse dixit, referencing Griffiths, which is a 2607 of the bundle, that is all but worthless. In a clinical negligence case, a bare assertion that something is standard practice or that something is unacceptable is not enough.
Could you demonstrate that by reference to, for instance, having cross-matched blood?
I'm sorry, I didn't.
Sorry, could you demonstrate that it was a bare ipse dixit in relation to the need to have cross-matched blood on site prior to this TURP?
The O+ transfusions. The O+ transfusion was first made at 5:40 in the evening after 3 units of cross-matched A+ blood, and that's at 1095. Dr. Pitt Miller says that permission in an emergency, or that it would be permissible in an emergency, if from a haematological perspective...
I do apologise, but it's not ipse, it's not... The expert evidence was that you should have cross-matched blood available, 2 units of it, prior to the TURP being carried out in case there was excessive bleeding. And that is a standard requirement. And the sense of it is self-evident. Namely, you want to have the appropriate blood to transfuse if something goes wrong. Okay? Now, is that ipse dixit, or is it a reasoned approach by an expert?
If all that is said is, I would have hoped that it would be delivered sooner, then that contains none of, which of course is precisely what Miller says at 831, that contains none of the reasoning process. It contains none of the meat to enable the court to decide what the standard of care was. I would have thought that it could be delivered sooner.
As I understand it, the evidence of Dr. Pittmiller on this point, I'm looking at paragraph 22 of her witness statement, was that it was standard medical practice to ensure that there are at least 2 units of grouped and cross-matched packed red blood cells in refrigerated storage. Standard
misunderstood point. Yes,
standard medical practice is the way she puts it.
There was no dispute that 2 units of cross-matched blood needed to be there in readiness for the TERP. There was no dispute about that. There was no dispute about it, and by the time the evidence ended, there was no dispute that it had been there. My learned friend did eventually, and it looks from the transcript as though it was very hard work indeed, get the concession that the 2 units were there, and it's at page 902. Now, against that background, we say that the refusal, effectively, on the part of the trial judge and then on the part of the Court of Appeal to accept that evidence and say, well, actually, I don't think it was there, was really verging on perverse. But as an example, my lord, there was no dispute about the need to have the 2 units of cross-matched blood at the time of the TERP. So there didn't need to be any further exploration of that because there wasn't any element of a challenge to that. It might well have been, and one can take that as, well, yes, that is an acceptable standard because everybody accepts that that was what needed to be there. But obviously on the other issues, and the ones that I was identifying, my lords, are the O+ transfusion, the massive volume of, I'm using the terminology that was used at the trial, of the fluids, and the timing of the transfusion. Those were things where there wasn't a consensus that there needed to be, for example, 2 units of cross-matched blood. And where there wasn't a consensus, then it isn't enough, we say, and obviously both take the same approach, that it isn't enough to simply say, well, this is what we say there should have been. Because there is obviously, and the example that I was giving in response to what I'd understood, obviously wrongly to be the question was asked by my lord, was in relation to the O+ transfusion, because what we know there from Dr. Pittmiller, the anaesthetist, is that it is permissible in an emergency if your haemoglobin is so low as to be life-threatening. She says that at 475. What counts as an emergency? We don't know. She didn't say, and it's obviously not up to the defendant to be trying to fill the gaps. This isn't a question of the O+ blood that was transfused being always a categorically impermissible step for any doctor to take at any point. It is permissible in certain circumstances, but she doesn't give any detail about the circumstances when it might actually be all right. And that's the range of opinion. That is what counts in this. The patient doesn't stop bleeding for hours and hours and hours after this point. Dr. Goetz hasn't been able to stop Mr. Tesheira from bleeding. And there's absolutely no attempt given by Dr. Pittmiller to be exploring, and this of course goes to the question of the partiality of her evidence that my friends make much of in their case. There's no attempt to actually explore the circumstances in which the transfusion of O+ blood is actually not completely forbidden, completely stupid decision, absolutely not something anyone could possibly do, but within the range of reasonable decisions that could be made in those circumstances. That's where the
I'm sorry, I may well have misunderstood this aspect of the evidence, but I thought she said somewhere that transfusing O positive whole blood was acceptable only in dire emergencies.
Yes, when it's a 475, my lord, that the if the haemoglobin levels are so low that it's become life-threatening. What does that mean?
So, well, she has explored.
How low? How life-threatening does it have to be? And we've got Mr. Tesheira on the operating table bleeding out. They don't stop the bleeding for hours after this. So this is really questions of judgment. At what point does it become reasonable to be infusing O+ blood, which is not completely forbidden? Even she doesn't say it's completely forbidden, completely stupid decision. And that's where we say there needs to be some analysis of the standard of care. You can't just say, O+ blood is not acceptable. It's not justifiable. Because she does then say, well, it can be justifiable in some circumstances, but she just doesn't actually put any flesh on the bones. And that's not something that's up to the defendants to add the flesh by asking further questions, or, of course, by making a decision to call evidence. It stands on her case as it is. So that is just the bare assertion that we say doesn't come with anything like sufficient justification to enable the trial judge or the Court of Appeal to say, yes, the standard of care has been breached.
I thought she discussed the fact that the haemoglobin level, while low, was not dangerously low, and therefore it wasn't a life-threatening situation, and therefore it was, I think the way she puts it somewhere, is a dangerous step to transfuse O+.
There's no attempt at saying how low is life-threatening. How low is life-threatening for this specific patient, given that we know that the specific patient had less than ideal, as things turned out at the end, less than ideal platelet levels, a lower than normal haemoglobin level months before the surgery. And that's where there needs to be more assistance given to the court by an expert seeking to discharge an expert's role. As far as the transfusion of the later products is concerned, so after, leave aside the O+, but what happens after that, as accepted 257, there was no evidence of the standard of care for the transfusion of the later products, referred to as being a massive volume of fluids. Well, not seeking to sound disrespectful, but really, so what? What does that mean? A massive volume of fluids? That is meaningless, we say, without more, and that is a bold assertion. And it's not open, say, to the Court of Appeal to say, well, it's not a scientific or a technical matter, as they do at 1493. When a medical professional has done something, whether a medical professional has done something that no reasonable professional in his post would do, is absolutely a scientific matter. And one can't say, well, there was a massive volume of fluids that were transfused, and therefore the appropriate standard of care would be to transfuse a lower volume. It simply doesn't work like that. One has to have, we say, the evidence from the claimant's experts as to what the appropriate volume of fluids would be. Is there a range? Would it have been, after you reach the point of 9 pints have been transfused, it's categorically everything over that point is unacceptable? Or, probably rather more likely, is it a question of nuance and clinical judgment? And we don't know because the experts didn't say so. Just about the timing of the transfusions, but in fact I think a lot of that has been covered already, and I'm conscious of the time. I don't want to go into that, and I appreciate the point that my lords have made about there being concurrent findings about the 2 units of cross-matched blood. The difficulty that, of course, the defendants have, or the appellants have, is that the evidence was there and was clearly accepted by the experts at the conclusion of the cross-examination, that the 2 units of cross-matched blood were there. So to the extent that the Court of Appeals, and the trial judge and the Court of Appeals would say, well, because of tags, then actually it was open to the trial judge to accept that it wasn't there. Well, no, it really wasn't by that point. The third point, my lords, that I seek to make is about causation. Our written case sets out how the trial judge got it wrong, because he starts on the basis that the death of Mr. Tesheira calls for an answer. He concludes that he's entitled to infer causation 1223, 1224. The Court of Appeal, of course, overruled the trial judge on a few points of causation. And what remained? The PT, or the preoperative PT tests, said in the case, this wasn't pleaded, the monitoring of the transfusion of this massive volume of fluids, the transfusion of the O+ blood, and the delay in transfusion. The preoperative PT and PTT tests, this is an omission, it's not a positive act. Litho deals with causation when it's an omission, that's at 2255 of the bundle. It is incumbent in those situations for the trial judge and then the Court of Appeal, when they're considering it, what would have happened? What would these PT and PTT tests preoperatively have shown? And there was absolutely no evidence on that at all, and more importantly, there was no attempt to work through what they might have shown. Without that, how could the trial judge, and then how could the Court of Appeal possibly have been satisfied that doing these tests preoperatively would have made a difference? So there's an essential tool, an essential step missing when both of the lower courts were considering causation. So too with the monitoring, or the failure to monitor of the fluids. Again, it's an omission. We know what the experts say should have happened as the steps that ought to have been taken by the people that were in the operating theatre, or the nurses, is not clear. But what neither the experts nor either of the lower courts grappled with was what would have happened. What would have been done differently if this monitoring had been carried out? What would the monitoring have shown, and what different steps would then have been taken by this team, and of course by any reasonable anaesthetist? What would these steps that the experts maintain ought to have been taken? What would they have shown?
That all depends.
Would have altered the course of events?
It all depends on what the monitoring would have shown. If you had monitored and you got the results, then the expert could have said what should have happened.
No.
But if you don't actually do the monitoring, I mean, the medical treatment nowadays is so up to date because you don't need to send blood samples off to laboratories and wait for a long period of time for them to come back. You have on the site immediate information available through monitoring devices. And you can react to those, the information you get in real time, immediately. And so the failure to monitor, you say, well, what does the monitoring show? Well, by virtue of the fact that you didn't monitor, nobody knows.
Well, but what could they may have shown, I mean, this is, of course, exactly what they say in Bulletin when you're dealing with causation arising out of omissions, that you do actually have to, if you're the trial judge and then the Court of Appeal deciding causation afresh, you do have to engage with this. And the difficulty, of course, is that because the experts didn't, then neither of the lower courts had that material. Yes, what could the monitoring have shown? But then, of course, more importantly, what would have been done differently? Because we know that Mr. Tesheira continued bleeding. We know that Dr. Gertz could not stop the bleeding until literally as they were sewing the poor man up. What would have been done differently? Would they have transfused less? No one knows.
Well, if the monitoring showed that there was fluid overload in some way, then you wouldn't put in more fluid. You would let the patient run dry. And there are plenty of operations where the patients are deliberately run a little bit dry.
Well, where you've got somebody who is continually bleeding for a period of 10 hours, is that the case? Well, we don't know because the experts didn't say. And that I appreciate the difficulties that your lordships have. You're looking at this the third time, which is highly unsatisfactory. But this ought to have been dealt with at both of the lower courts. And it's not enough, we say. They say, well, something would have been different. What would have been different? At what point should they have stopped infusing further fluids, and at what point was the die cast?
Sorry, what we seem to be looking at is a very large amount of detailed and uncontested opinion evidence from an eminent anaesthetics expert.
But
now what you'd like us to do is ask a whole load of questions about other aspects of the evidence, some details which might have been picked up, but unfortunately it's rather too late for that, Ms. Steele. On one view.
They're making errors of causation, or errors in the approach to causation, then it's not too late for that, because the board can, of course, put right errors of law. And there was no attempt made by either experts or courts to go into these important questions of causation. By the time it finished up in the Court of Appeal, then an awful lot of the original findings of breach had been kicked out. And then they had these different ones. What difference would these steps, who knows what these steps should have been? We don't know because the experts didn't say. And because the experts didn't say, then the trial judge and then the Court of Appeal didn't have anything to deal with to be able to know at what point the die was cast. Now, of course, to an extent, we say this is relevant because you'll appreciate from the notes that poor old Dr. Roopchand had been discharged long before Mr. Tesheira died, that it was Mr. Chashgoon that was, Dr. Chashgoon that was stabilising the patient. But one gets into difficulties, of course, where one just assumes that there's an obligation of result on the part of the anaesthetist who starts early in the day. But there is no excuse in my submission for the fact that the experts did not, I want to say, massive volumes of fluid. There is at no point is there any attempt from the experts, or indeed from the trial judge, or indeed from the Court of Appeal, to say what ought to have been done differently. And with respect, my lord, it's simply not good enough to say, well, they would have noticed that he was overloaded and they'd dried him out. We know that this was a patient who carried on bleeding for hours upon hours upon hours. The point at which the die was cast...
There must be a very, very fine balance between blood loss and excessive overload of fluids. And all that depends upon actually having some information upon which you can act. And if you don't have the information, it seems absolutely impossible to come to the right decision. And monitoring is an essential feature of that.
What, in effect, one ends up with is both of the lower courts making out causation essentially from the fact that Mr. Tesheira died. Had it all been done differently, he wouldn't have succumbed. And that is not a conclusion that is grounded either in the law of causation or, of course, in the evidence. Now, there are two, I'm actually all right on time, two further, it's the delay in transfusion and the O+ transfusion, which I can deal with very briefly. The delay in transfusing any of the blood products into Mr. Tesheira. Now, this is the point that is, if I may say, perhaps of rather more relevance than whether the blood, the 2 units of cross-matched blood were at the hospital at the time of the check or not. We say they were, the trial judge said they weren't. The blood products could have prevented, apparently, hypovolemic shock and DIC, that's at 1503. But no one could have known that Mr. Tesheira was suffering from hypovolemic shock until he collapsed. And the references are at 624 and 827 to 828. He was taken straight to the operating theatre. There were tests done immediately. He was already suffering from DIC by just gone 4 o'clock when the tests were taken, some point between 4 o'clock and 4:15. He was already suffering from DIC before any of the blood products could have been transfused, because nobody could have known that he would have needed the transfusions until he collapsed. And finally, on the point of the O+ transfusion, now this is a positive act, so straightforward negligence as opposed to questions of omission. I've already addressed your lordships on why we say properly analysed the decision to transfuse O+ blood did not fall within the scope of Dr. Roopchand's duty of care and how the evidence fell short on that. The Court of Appeal's conclusion on causation was that the transfusion of O+ blood is what caused his hypovolemic shock and then the DIC. And that is at 1505, paragraph 294. The O+ blood was first transfused at 5:40 p.m. And the timeline that I've just taken your lordships to, on the basis of the PT and the PTT tests taken at about 4:15 and received just after 5, he was already suffering from DIC at that point. He was already suffering from it about an hour and a half before the O+ transfusion.
I thought the Court of Appeal said that he had early signs of DIC.
I'm sorry, my lord.
I thought the Court of Appeal had found as a fact that it was early signs of DIC rather than he was suffering from DIC. I thought that was the finding of fact by the Court of Appeal. I could be wrong.
Of DIC, even more important to say that it could have been stopped. There's no attempt at doing that.
I'm sorry. I didn't know that there was a factual finding that he definitely had DIC at 5:40 p.m.
The references, I think, 473 to 1483, and then I've got a note which I can't read.
473 to
474 and 1483. But the Court of Appeal, their conclusion on causation at 1505 at paragraph 294 was that it was the transfusion of the O+ blood that caused the hypovolemic shock, which then led to the DIC. It cannot possibly have caused the hypovolemic shock, because the hypovolemic shock was what caused him to collapse at about 3:45, which was about 2 hours before the transfusion of O+ blood was given. Now, I appreciate that going through the evidence is not ordinarily something that one would expect your lordships to have to engage with, but the Court of Appeal had decided this point on causation afresh, on the basis effectively that it was common sense, and it simply doesn't work It doesn't work. And it shows the errors that the Court of Appeal made, we say, in attempting to put together the case that they did on the breaches that they had found, linking them in with Mr. Tesheira's death. Mr. Tesheira's death was a tragedy which has had catastrophic implications for many of those that were involved on that day, and obviously there is enormous sympathy for the Tesheira family. But the case that the claimant brought to trial, by the end of her evidence, did not show a case for Dr. Roopchand to answer. Might well have shown a very, very good case for Dr. Gertz to answer. Did not show one for Dr. Roopchand as the anaesthetist. The defendants weren't under any obligation to fill in the gaps for her. We say the same as Gulfview, that the submission of no case to answer should have been made and should have been upheld by the Court of Appeal. Counsel coming in under a time estimate. No, I've covered that in my written case. It's not. I wasn't intending to take your lordships to anything further on that. Unless I can assist.
You've completed your submissions. Thank you, Monsieur. Well, we'll adjourn to consider where we've got to with the submissions. And we'll either be back by 4 or Usher will, or we'll consider the matter overnight and let you know tomorrow morning what the position is. But we'll try to come back before 4 o'clock if we can. Now, Mr. Mendes, we've decided that there is one issue that we would like to hear your submissions on tomorrow morning, and that is the, if I can put it this way, the allegation of unfairness in that the case established against the defendants is said to have been based on a non-delegable duty of which the defendants had not been given fair notice in the way in which the case had been conducted, at any rate prior to closing submissions before the trial judge.
Thank you very much.
I hope that's clear.
Yes, it is.
Thank you. Well, in that case, we'll hear you on that issue at 10:30 our time, UK time, tomorrow. And in the meantime, the court will adjourn.
Much obliged, my lord.